Well, hello everybody, and welcome to our talk on the development plan in 2020, which is going to be presented by me. I'm Isabella Tafur, and by Charles Streeten. And Charles and I are going to run this as a bit of a double act, so you'll be able to see us both and we'll be chipping in. And at the outset, can I encourage you, you'll see at the bottom of your Zoom screen that there's a question and answer facility. And can I just encourage you all, please, do submit questions as we go along. And to the extent that we can, we'll have a look at them as we're going through our slides and address them where we can. And if not, we'll look at some of them at the end and work through those. But it's a slightly strange forum in that we can't see you, and it's nice for us to see that you're engaged. So please do take the opportunity to ask us any questions. So our talk today is going to explore the role of the development plan in decision making in 2020. And we're going to start with a short history of the approach that's been taken to the development plan since the introduction of the NPPF in 2012. And without wishing to spoil the story, it ends with the importance, the primacy even, of the development plan. So with that in mind, we'll then look at the principles which establish the role and approach that should be taken both to the development plan and the NPPF in planning decisions. And we'll then look at two case studies which illustrate the importance of recognising the primacy of the development plan in section 78 appeals.
Thanks very much, Isabella. So the way in which we've looked at this is to break down the chronology of the life of the NPPF so far into 4 phases. And the first phase is the sort of 2011-2012 period before the framework came into being. Many of you, I'm sure, will remember that the framework was a big part of the Conservative agenda to cut red tape and to stimulate economic growth, in particular in relation to house building. So we'll look at the background to the framework and then how that develops in 2012 into the brave new world. And Isabella, I think, particularly remembers the days where the framework was the be-all and end-all of planning, where everything anyone said was NPPF driven. So that's phase 2, and we think that lasted sort of 2012 to 2014. Phase 3 is 2015 to 2017, where there's something of a clash of the titans between the NPPF and between the development plan. And there are a number of court decisions, perhaps the first of them being Crane, the case where it was said that the framework didn't displace the statutory primacy of the development plan, running through to Hopkins Holmes in 2017, where the Supreme Court, we say, more or less settled the position in relation to how the framework and the development plan interact. So that's our phase 3. And then there's a fourth and final phase, which is now we've called it the Resurgent development plan. It's really the status quo and how the development plan should be applied in planning decision making in 2020 and a look to the future after that.
Okay, so firstly, just responding quickly to a question that's been submitted. We will make these slides available to you afterwards, so don't worry about note taking. You can just listen to what we say and we'll send around the slides. And I think there'll also be a recording available afterwards. Okay, so the beginning of the story then, I was a pupil in Chambers in 2011 and I started properly in practice in 2012. And the NPPF was obviously big news. It seemed when it came out that it had supplanted the role of the development plan and everything was about the NPPF. So the start of that story was 2011 with a consultation draft, and then the final version obviously came out in 2012. And when it came out, safe to say it caused something of an outcry. You'll see a reference there to the Telegraph, which ran a campaign under the heading "Hands Off Our Land," with over 100 articles criticising what it perceived as a watering down of the safeguards that had protected the countryside for over 70 years. And it's true to say that in the years immediately following its publication, the focus really did shift from the development plan to the framework, which became the primary focus for planning decision making. Charles is in charge of the slide, so he has to read my mind and know when I want him to change. Okay, so this, I've taken these figures from the Planning Inspectorate's statistical analysis of appeals, which have been allowed between 2010 and 2019. And the lines that I've highlighted in yellow show the practical effect of the shift in focus away from the development plan and towards the NPPF. So you'll see that in 2010-11, before the NPPF came out, the proportion of appeals allowed stood at 37%. That's the penultimate column on the top row. And in terms of number of dwellings allowed on appeal, that equated to 45%. Following the introduction of the NPPF, those figures began to creep up to a high point in 2013-14, where 52% of appeals were allowed, which translated to 65% of dwellings permitted on appeal. Since that high point, there's been a gradual reduction, albeit the figures were higher in 2014 and to 16 than before the NPPF was published. But you'll see that by 2018-19, we're almost down to the pre-NPPF figures with just 38% of appeals allowed.
Yeah, I think that point in 2015, where the figures were at their high point, it was when I joined Chambers. I joined Chambers as a tenant in 2016, I think, and I was a pupil in 2015. And I remember sitting in my leader's room and another silk from Chambers coming in and saying, "Oh, have you seen this judgment in Crane? It says that the NPPF doesn't displace the statutory primacy of the development plan. I mean, how weird is that?" And my pupil supervisor said, "Well, actually, that was sort of the result I expected." But it seems now, looking back on it, incredible that was the sort of debate that was happening.
So this next slide looks at the second to fourth phases that Charles outlined at the beginning. And the 2015 we've called Tensions Explored. And things by this stage had become so focused on the NPPF that cases were coming to court with claimants arguing that conflict with development plan couldn't possibly justify the refusal of planning permission in circumstances where there was no 5-year supply. And that was the argument in Crane. So the question for the court was whether the Secretary of State who'd called in the appeal had been entitled to give very substantial weight to the development's conflict with the recently made neighbourhood plan in circumstances where the local planning authority couldn't demonstrate a 5-year supply, so that the policies in the neighbourhood plan were deemed to be out of date. And the claimant said that having found that the neighbourhood plan policies were out of date, the Secretary of State couldn't then resurrect them by attributing very substantial weight to the conflict with those out-of-date policies. That, the claimant argued, would nullify the presumption in what was then paragraph 14 of the NPPF. And the court rejected that argument, and it explained that the NPPF hadn't changed the statutory presumption in favour of the development plan, and that it was a matter of judgment for the decision maker how much weight should be attributed to out-of-date policies. In some ways, it's slightly surprising that the court had to say that. Obviously, section 38(6) hadn't changed, and the NPPF itself said in terms that it didn't purport to change that approach. But this was the first time that it was said by the court, and it was big news in Chambers, certainly, as Charles has just explained. But in my view, the real turning point came with the Court of Appeal judgment in Gladman and Daventry in 2016. And in that case, the court criticised what it described as the inspector's excessively narrow focus on the NPPF. And both the High Court and the Court of Appeal agreed that the inspector's decision to grant planning permission should be quashed as a result of his flawed approach. So in that case, the relevant development plan had been adopted in 1997, and it was intended to run to 2006. Some of its policies had been saved, but plainly the policies were pretty old by the time the appeal was heard in 2015. Two of the saved policies sought to protect the countryside and to limit housing in certain specified villages to small-scale infill development. And the inspector found that given the age of the policies and their lack of consistency with the NPPF's thrust towards boosting housing supply, they should be given little weight. And the courts found that the inspector had gone wrong in the way he treated those policies. The right approach would have been to determine whether those two policies were consistent with the NPPF looked at as a whole. But instead, the inspector had focused unduly on paragraphs 47 and 49 of the NPPF, which spoke about the importance of boosting housing and deemed certain policies to be out of date in the absence of a 5-year supply. But just because the policies were adopted years before the NPPF and against a background of a now revoked structure plan, didn't necessarily mean they were inconsistent with the NPPF. They still formed part of the development plan, and they were still entitled to the priority accorded to them by section 38(6). So that was a clear example of the Court of Appeal reasserting the primacy of the development plan, regardless of its age. And we'll come back to that case in some of our later slides. The equilibrium phase then that we've set out at the bottom of the slide really came with the Supreme Court judgment in Hopkins Homes. You'll remember that that case actually related to two separate cases, Hopkins and Suffolk Coastal and Richborough and Cheshire East. And at first instance, the case was really about restrictive policies and whether green wedge policies should be treated as policies for the supply of housing and therefore deemed out of date in the absence of a 5-year housing land supply. And there were a number of cases going in different ways about whether a broad or a narrow interpretation should be taken to the phrase policies for the supply of housing in the NPPF. The Court of Appeal had taken a broad approach and said that green wedge policies were policies for the supply of housing because they had the effect of restricting the places where houses could be built. But when the case came to the Supreme Court, it really used it as an opportunity to completely review the law in relation to the framework. So it asked and considered what the status of the framework was, where the power to make it came from, and how it interacted with the development plan. And in considering those questions, it disagreed with the Court of Appeal and said policies for the supply of housing didn't include green wedge policies. Interestingly, it also refused to quash the inspector's decision letter, notwithstanding that finding, on the grounds that it wouldn't have made any difference, because in the absence of a 5-year supply, the Supreme Court said the focus shifts to other material considerations, including the NPPF. So here we think a kind of equilibrium was established between the development plan and the NPPF. The starting point remains obviously the development plan, but the Supreme Court found that where there's no 5-year supply, the focus and prominence given to other material considerations, including the NPPF, would increase. Now, it's fair to say that some sections of the industry have been slow to respond to the change in emphasis heralded by the court's decisions in both Gladman and Daventry and Hopkins Homes. And those sections still haven't recognised the importance of the development plan in promoting their developments. And we'll see on the next slide how that failure plays out in planning appeals.
Yeah, and just to come in there with one of the questions that's come in, Isabella, while you've been talking, John Careford's asked us, is the reduction in the number of appeals recently also to do with the fact that more LPAs have up-to-date local plans in place, so it's easy to give primacy to a development plan when one exists? And there's really two things I'd like to say about that, and I'm sure you'll have some thoughts as well. The first is that almost in every case, and I can't think of a case where the development plan has been absent, a development plan does exist. The question is whether or not it's up to date. And as we're going to go on to explore, that's actually not always the most important question. Even where you have an out-of-date development plan, both planning inspectors, local authorities, and the courts recognise the importance of a plan-led approach to decision-making. And the second thing I wanted to say was perhaps just to give a kind of practical example of that. There was a case I did for West Oxfordshire, where it was what you might think was a very good scheme was being promoted. It looked a bit like infill development. It was high quality. It had a sort of little thatched cottage, good dwelling sizes, everything like that. And it was before West Oxfordshire had its new local plan, which is now adopted. But it was really shortly before that. And the inspector refused planning permission in that case on the basis of non-accordance with the old development plan policies in combination with some heritage harm. And it was a case where one of the tactical mistakes, I think, was that the developer had really relegated the development plan not just to a kind of B-list celebrity, but to a Z-list celebrity. It didn't really care about development plan policies. It said, well, those are all out of date. Who cares about those? Countryside protection, that's not relevant. You don't have a 5-year housing land supply. We as the local authority held our hands up, said, yeah, we don't have a 5-year supply of housing land, but that doesn't mean the development plan isn't important. Some of these policies are going to be carried forward into the new plan. Even policies which aren't being carried forward nevertheless represent the adopted vision for this part of the country. And that strategy was enough to defeat what, frankly, on its face looked like quite a good scheme. So I don't think just because the development plan is out of place, it should be written off. And that question perhaps kind of highlights the point that we're going to try and make throughout.
Okay, so this next slide, I've taken these images from an article that was published earlier this year in Planning Magazine, and they show the number of housing appeals allowed on unallocated sites since 2016. First for large developments of more than 400 houses, and then in the one on the right-hand side for housing schemes between 200 and 400 units. And the premise of that Planning Magazine article is really that the phrase tilted balance used to strike the fear into the hearts of local planning authorities, because it made it so difficult for them to resist housing appeals on unallocated sites, but that those days are now numbered. And this trend shows that both, according to the article, both the Secretary of State and his inspectors are now swinging their focus away from just housing numbers to questions of landscape and heritage impacts, which has the effect of retilting the balance against schemes that don't accord with their plan. So for the larger schemes, the data shows that in 2016, so the blue ones, the blue columns are appeals that were allowed and the grey are appeals that were dismissed. So in 2016, some 46% of housing appeals on unallocated sites were allowed. In 2017, it was 75%. But then in 2018, no such appeals were allowed. And in 2019, just one was. And the figures on the smaller scale schemes show a similar trend. So you can see there are 23 appeals on unallocated sites allowed in 2016, then 16 in 2017, 7 in 2018, and just 6 in 2019. And I think that's a trend that's been felt in the development industry, where the general sense is that it's becoming harder to secure permission on unallocated sites now than it was in the heyday of the NPPF. And with that renewed focus on the development plan, it's particularly important now to understand how the development plan should be approached.
Thanks, Isabella. Another question, perhaps one for you this time. It says, is the timeline to a degree a result of the time it takes for cases to go through the different levels of courts?
That certainly may play a role, but if cases are going through the courts, generally speaking, one would expect that to be developers challenging refusals. Not exclusively, of course, but they tend to be slightly more litigious than local planning authorities who've lost appeals. So I wouldn't expect that really to affect the trend very significantly.
Great. So if we move on to the next slide, if I can get it to work. There we are. What we want to do in light of the thesis that we've been expounding, which is that the development plan shouldn't be forgotten, is to try and set out some sort of key principles, a robust set of things to remember when making a planning application, when putting together a proof of evidence, or when determining the planning application, which should ensure that the approach to the development plan is right. And although these are extremely basic, they are definitely planning 101. I think both of us are probably surprised in our professional experience how often a failure to grasp these kind of nuts and bolts basic principles results in a significant tactical advantage to our clients when we start picking at proofs of evidence. And it's often that you see something in a proof of evidence which is a sort of a loose strand on the development plan. You think that just doesn't sit quite right with the basic principles. And the more that you tug on it in cross-examination, the more all of the evidence starts to unravel, like kind of pulling an item of clothing off, and you end up with this bare naked truth at the end, standing there slightly shy and embarrassed. Which is a fundamental misunderstanding in relation to one of these points. And so what we're going to try and do is avoid that public nudity and give people a robust set of principles to apply in every case. And I think there are really three overarching principles I want to dwell on at this stage. The first is that the English, Welsh, Scottish planning systems are plan-led. The word is planning. It's not development control. We in this country have adopted through Parliament a system which is proactive rather than reactive. It doesn't expect proposals to come forward and then seek to deal with them on a case-by-case basis. It seeks to promote a coherent scheme across a local authority for a time period and then to determine applications in accordance with that coherent scheme. And that was something which in that key case of Gladman and Daventry, perhaps the hard point of that case, Philip Sales stressed. He said, look, there's a plan-led system, and in every case, there is a public interest in promoting the coherent development of a given local authority's area. And in Hopkins, that's stressed as well. Robert Carnworth points to sections 13 to 19 of the Planning Compulsory Purchase Act 2004 and explains why it is that local authorities are required to produce a development plan. There's a statutory basis for that, and says, look, that's the way that planning works in this country. It's designed to accord with a plan, albeit that there may be circumstances where you just justify departure from that plan. So principle one is, remember, planning is always supposed to be plan-led. Point two is that the development plan has statutory status. Firstly, it's a mandatory relevant material consideration, see section 70 of the Town and Country Planning Act 1990. And secondly, section 38(6) of the Planning and Compulsory Purchase Act 2004 means that there's a statutory presumption in favour of the development plan. So whenever you're taking a planning decision, you look first at the development plan, you work out whether it accords with the plan, and if it doesn't accord, you need to justify the departure from that plan. There needs to be a reason why development which doesn't accord with the development plan should be granted planning permission. That is another relevant material consideration of some sort. And to achieve that approach, I think there are three steps that need to be considered. Step one is to work out what the relevant policies in the development plan are. That's the City of Edinburgh case. Look at the development plan, pick out from it the policies which apply in a given case, housing policies, for example, landscape policies. Section two is work out what those policies mean, properly interpret the policies in the plan. And then point three is form an evaluative judgment on the broad question of whether or not the development accords with the plan read as a whole or doesn't accord with the plan read as a whole. And that's something we'll come back to, but it's important to remember that in most cases, that is where the scope for judgment really applies. The relevance of the policies is going to be very difficult to have a meaningful dispute about. The interpretation of the policies is a matter of law. The judgment comes in at the third stage where you're asking yourself, does this accord with the plan or not? So that's key principle two. There's a statutory basis for giving the development plan primacy. And then key principle three is that the NPPF is not a plan. What it is a statement of government policy. And it has, of course, a statutory basis, particularly in the context of plan making, where It's a big part of the examination of development plan documents. But what the framework is I say, it's the government's policy on how development control decisions should be made and what principles should inform the planning system. But what it is not is a plan itself. It's not itself seeking to direct development in particular ways. That is left up to local authorities whose development plans have statutory primacy. So I think if you remember those three key principles as a basic building block, and remember that the NPPF is another material consideration and a reason to look away from the plan rather than a plan in and of itself, that will massively improve the way in which you understand the development plan in a decision-making context.
Okay, so in terms of the steps that Charles just mentioned, the first is identifying the relevant policies, and the second is figuring out what they mean. And as he said, the interpretation of planning policy is a matter of law. And we're going to look in a moment at a couple of cases which kind of crystallize the court's approach to the construction of the development plan. But I've put together on this slide 5 key points about the construction or interpretation of the development plan. They may be familiar to you, but they're important to remember, and they set the scene for the cases we'll mention in a moment. So firstly, the development plan should be read as a whole. And it shouldn't be read as if it were a statute, but rather what it is, which is a guide to practical decision-making and to directing development to certain locations. The policies in a plan have to be interpreted objectively in accordance with the language used, read in its proper context. And that context includes a number of things, according to the court's interpretation over various judgments, but it includes the overriding objectives of the plan. So Charles is right, you do have to start by identifying the policies that you think are particularly relevant to your case, but that shouldn't be to the exclusion of the wider aspects of the plan. So lots of plans have a general kind of objective section at the beginning, or a kind of descriptive spatial strategy with bullet point aims. And those parts of the plan are very important in understanding what the policies that follow it mean. So the overriding objectives of the plan, the specific objectives to which the policy is directed, which may be set out and explained in the explanatory text around that policy, other development plan policies, because whilst policies in a development plan do sometimes pull in different directions, you have to understand the context in which the particular policy you're looking at kind of fits into the plan. So surrounding facts and materials, and also supporting text. And policies in a plan shouldn't be construed in such a way as to negate the plan's spatial strategy. So if, for example, at the beginning of a plan, you have a section on spatial strategy which says that the plan is to focus development to urban areas and protect the countryside, for example, then all of the individual policies in the plan should be read and interpreted having regard to that aim, and should be construed in such a way that seeks to further that strategy rather than to nullify it. And the particular example that I'm going to speak about on the next slide illustrates that point. Okay, so the first case on this slide is Gladman and Canterbury, and it's a case that I was involved in. It relates to a housing appeal for a scheme in Canterbury, and the development was on a greenfield site outside of a village. Canterbury's local plan was quite old by the time this appeal was determined, but it had a number of saved policies, 2 of which were particularly relevant. One of the policies encouraged housing development in urban areas, and the other was permissive of small-scale infill housing in certain villages. Now, this scheme wasn't in an urban area, and nor was it small-scale or indeed in a village. So I appeared for the local authority at the inquiry, and I argued that the scheme was contrary to the development plan because it wasn't in accordance with those key policies. I said that if a plan identifies locations where housing will be permitted, it seemed to me that there had to be a negative corollary that went with that, which meant that housing in other places wouldn't be in accordance with plan. Unfortunately, the inspector didn't agree with me, and he accepted the argument put forward by Gladman, which was that all those two policies did was to offer support to housing development in certain locations, but they didn't prevent or restrict housing in other places. And the inspector in his decision found that the scheme didn't find any support in those two particular policies, but because they were expressed in permissive language, i.e. they said development will be permitted here and here, he said that this scheme wasn't in conflict with them. And according to the inspector, it was wrong of me to say that just because some locations were identified development, it must follow that that development was precluded in others. He said that there was no concept of an implicit policy in the NPPF, and indeed it would amount to a presumption against development other than that permitted by a local plan, which would run counter to the presumption in favour of sustainable development. Now, you might think that's a little bit strange, certainly I did, because there is a presumption against any development that doesn't accord with the development plan. And that may run counter to the presumption in the NPPF, but it is a presumption that has statutory force. So I'm happy to report that the courts, neither the High Court nor the Court of Appeal, agreed with the inspector. And they found that it was a fallacy to suggest that simply because a policy is expressed in permissive language, that it has nothing to say about housing in other locations. The two policies I mentioned before, one allowing development in urban areas and one allowing infill in certain villages, those two policies, the court found, formed a suite of policies for housing development, which left out of account none of the locations where development might be permitted. So housing development on a site that wasn't identified in those policies would not be in accordance with the plan read as a whole. And you'll see if you look at the judgments that the courts reached that interpretation by construing the particular policies with specific reference to the strategic aims of the plan, which were in those bullet points I mentioned at the beginning. And in that kind of descriptive section of the plan, it emphasised the aim of the council to focus development to brownfield sites and to protect the countryside. And even though there was no countryside protection policy in Canterbury's plan, because it had been part of the structure plan that had been revoked, those objectives were relevant when you came to interpret what the particular policies in question meant. And so because of the inspector's failure to recognise the conflict with the development plan, the result was that his decision had to be quashed.
Thanks, Isabella. So I'm going to deal with a case which really follows on from Isabella's Gladman and Canterbury case. That's the case of Corbett and Cornwall Council, which is very recently decided this year by the Court of Appeal. And I think what's really important about the Corbett case is the way that it clearly draws the distinction between the interpretation of the development plan, which was what was critical in Isabella's Canterbury case, and the application of that plan and the broad judgment in relation to whether or not a development accords with the plan. The case related to the extension of a caravan park in a designated area of greater landscape value down in Cornwall, and the council's approach was to find that the development would harm the landscape and therefore didn't accord with the policy which protected the area of greater landscape value, but that it was supported by the policy in relation to tourist uses, where particularly in Cornwall there's a serious policy or suite of policies which support tourist uses in that area. And so what the local authority did was say, yes, there's conflict with one of these policies, that's the landscape policy, but there's accordance with another of these policies, that's a tourism policy. And so our view in the round is that this development accords with the development plan. That was challenged to the High Court, and Mr. Ockleton, sitting as a Deputy High Court judge, not a judge whose judgments I always agree with, said, in my view, this is all a question of interpretation, and looking at the development plan, it says planning permission will only be granted for residential developments which do a number of things, one of which is preserve areas of greater landscape value. This development doesn't preserve the area of greater landscape value, and therefore this development does not accord with the development plan read as a whole. That was appealed by Mr. Corbett, the owner of the caravan site, to the Court of Appeal, and his appeal succeeded. Lord Justice Lindblom says, no, that approach taken by Mr. Ockleton at first instance wasn't quite right. When one looks at this, one needs, of course, properly to interpret both of the policies, and one needs to recognise there is inevitably a conflict with the landscape policy in circumstances where the development will harm landscape. But that is not determinative of accordance with the plan as a whole. The question of accordance with the plan as a whole is a matter of judgment, and in circumstances where there was a tourism policy which supports the development, there's clearly a tension between development which is going to impact positively upon the tourist economy but negatively upon the landscape, and that is a matter for the democratically elected local authority as decision maker. And in reaching that judgment, there are a couple of key points I just want to draw out from the Court of Appeal's decision. The first is that it says there's no hierarchy of policies in the development plan, or at least in that development plan, and in relation to those policies properly read. They're just two different policies which tend in different directions. And so I think one needs to be mindful of that when forming judgments about the development plan, not to say, oh, well, this particular policy says only in these circumstances, so that must be the be-all and end-all. Things need to be weighed. The second is that the court accepts as a matter of principle that a breach of a single policy might mean conflict with the plan as a whole. And I think Isabella's, albeit a suite of policies, but Isabella's Canterbury case is a really good example of that. What the local authority had was a comprehensive approach to a particular type of development. It said where it could be, it said on what terms it could be there, and where you didn't accord with that, then you didn't accord with the scheme set out in the plan. But that's different from where there are different policies pulling in different directions. And in those cases where policies pull in different directions, what needs to be made is a judgment made as a whole. And the only caveat I would add at the very end of that is that when you're forming that broad judgment, it's easy sometimes, I think, to be drawn in by the attraction of being able to say, well, it's a matter of judgment, it's a matter for me, and forming a judgment which is beneficial perhaps to your case, but difficult to justify on the evidence. And as we'll see later when we look at some of the case studies, there are circumstances where trying to argue broad accordance on the basis that it's judgment actually is a really dangerous strategy, and the better strategy is to take a step back to say, yes, I recognise there's a conflict with the plan read as a whole, but there are good reasons to depart from it, and the extent of that conflict is perhaps limited. Moving on from there, I want to try and put the other side of the story now, the framework. We're going to look first at some basic principles and then at how the NPPF and the development plan should properly coexist in light of the judgments. But just to start the story with the framework itself, one of the things the court did in Hopkins, the Supreme Court of its own volition, said to the advocates, come on guys, can someone tell me what the basis for the NPPF is? Like, what power does the government have to issue this policy? What status does it have? There was initially a suggestion that it was the royal prerogative being used, and there's a consideration of that, and the court says, no, actually, this is a case where the power to issue the policy is statutory. And it's worth remembering that in the concept of plan making, the development plan is expressly something required to be taken into account in examining the development plan by the Planning and Compulsory Purchase Act. But in the context of decision taking, there's no reference anywhere in statute to government policy. And what the court said is that you can infer the power to make that policy from the existence of the statutory scheme. But that does very firmly place the framework into another relevant material consideration box. In some ways, it is subsidiary to the principal statutory approach, which is a plan-led system. And that's why, in Hopkins' Holmes, the court itself says that the framework doesn't purport to displace the statutory primacy given by statute and policy to the development plan. And so when you're looking at all of the policies in the NPPF, you need to remember that the judgments you form have to be exercised consistently with the development plan and its statutory primacy, and not in a way which displaces or distorts the statutory scheme. And indeed, it's worth noting that the framework itself has as one of its core principles that the planning system should be genuinely plan-led. And I think Isabella's now going to talk about how the courts have dealt with that.
Just quickly to come back to the Court of Appeal judgment in Gladman and Daventry, because in that case, the court made the point that the mere age of a policy doesn't cause it to cease to become part of the development plan. Even if it's old, it's still entitled to the priority that's given to it by statute. And the reason for that is because significant weight should be given to the general public interest in having plan-led decisions, rather than an unstructured free-for-all where local authorities are just responding to application after application. So the court said there that there may still be a considerable benefit in directing decision-making according to a coherent set of plan policies, even though they're old, rather than having no coherent plan-led approach at all. And given the court's clarification of that point, I think it's really important to remember that it's not enough just to put in your application or turn up to an appeal arguing that the plan is time expired, as if that somehow renders it irrelevant or really reduces its weight to a minimum level, because there is still that significant public interest in pursuing a plan-led planning system. And I think that point comes out again on the next slide.
Yeah, sorry, it's not changing for some reason. Hang on. I think it's when I get the questions up, it stops working on the,
okay.
Presentation.
So there's that same point again, because here under this slide, we're looking at the development plan and the tilted balance. And the Court of Appeal really in Gladman and Daventry made the point that some policies are effectively ageless. They're repeated in plan after plan, and they continue to be relevant and important in guiding development in a local authority's area, notwithstanding that many years have passed since they were originally introduced. And really, the Court of Appeal went further in saying that the fact that a particular development policy might be chronologically old is in itself irrelevant for the purposes of assessing its consistency with the NPPF, and thus whether it's out of date. And so in that case, as I say, there were policies directing development to particular areas, and the court looked at all the elements of the NPPF that approach was consistent with, reducing reliance on the private car, recognising the intrinsic character and beauty of the countryside. All of those were sound planning policies, which explained why there were policies of the type in Gladman and Daventry repeated in plans throughout the years. And just because one particular iteration was now old, didn't mean it could be set aside.
Thanks, Isabella. So in light of that, I just want to set out again some basic principles for dealing with the interaction between the development plan and the framework in the context of the tilted balance, because this is again one of the areas I think where sometimes people can't see the wood for the trees. So 3 simple steps, I think, to dealing with this. Step 1 is when you're considering whether the tilted balance applies, whether the development plan is out of date or up to date, what you need to do first is identify the most important policies for the purpose of paragraph 11. Which the most important policies are is a matter of planning judgment. And the way that the courts put it, as Mr. Justice Dove in the Wavedon Properties case says, you need to put those policies together into a basket, and you have a basket of policies, which are the most important policies. Some of those might be out of date, some of those might be up to date, and broadly you need to form a judgment on whether the basket as a whole is up to date or out of date. So that's step 1, put all of the eggs into the basket and decide whether the basket as a whole is out of date or up to date. Step 2 is if the basket of most important policies is out of date, then you need to explain that the focus shifts away from the development plan and towards other material considerations. And there have been a number of times where I've cross-examined witnesses and I felt that the best possible answer to my question would be, well, Mr. Streeten, in Hopkins Holmes, your Calmworth said that the focus shifts in circumstances where the development plan is out of date. So even though you're talking about that, my focus is really on other material considerations, in particular, the need for housing, the need for affordable housing, the need for this particular type of development, the quality of the development. And it's pretty rare, if not never, that I actually get that answer. So if I can give people a tip to throw back at me when I ask questions, it's the focus shifts to other material considerations if the eggs in the basket are no good. And then finally, something really important to remember, often forgotten, is that even when you're doing that tilted balance calculation and asking yourself, does the harm from the development significantly and demonstrably outweigh its benefits, you have to take into account policy conflict with the development plan at that stage. That really was one of the questions that was first answered in Crane. It was said, yeah, even when you're doing that tilted balancing exercise, you need to consider the policy harm in departing from the plan. But it was re-litigated in the context of the 2018 framework very recently in Gladman and the Secretary of State, a name that comes up often in these cases, Gladman, where the court again said, no, that the development plan is at the heart of the plan-led system. So even when you're asking as an other relevant material consideration, does the harm significantly and demonstrably outweigh the benefit, you still need to take into account the policy context. And I just thought before we move to the next slide, I'll deal with another of the questions that we've got. This one's from David Broadley. I think it's another of his questions. He says, I presume we're clear that a local planet examination with main modifications made to address objections does not form part of the development plan. And I'll pause there and say, yes, that's absolutely right. It only becomes the development plan when it's adopted as the development plan. And he says, however, encouraging the inspector's findings might be, I'd like to ask if moderate weight can be given to those policies and proposals subject to main modifications that are involved in Section 78 planning appeals this summer. Well, I think an answer to that might provide some sort of route map is a recent Secretary of State's appeal decision in a case that I did that we're actually going to use as a case study, the Camberwell Union case. And something I wasn't going to talk about, but which deals specifically with this, is the status of the London plan. And in that context, as we'll say later, the Secretary of State has issued directions in relation to particular policies in the London plan requiring modifications before the plan can be published. And he issues this appeal decision looking at the importance of the emerging London plan as part of it. And he says in relation to the policies where he's issued directions that moderate weight should be given to those policies in the London plan. So that's precisely the approach he gives, where he hasn't suggested that modifications will need to be made and he hasn't issued a direction, then he gives significant weight to the policy. But where there's going to be changes, the Secretary of State gives moderate weight. So I think the answer to the question is a straight yes. I don't know if Isabella has anything to add, otherwise we can go on to the next slide.
I just add that obviously when you're looking at weight to attribute to emerging policies, you'll have to look at the stage that the emerging policy is reached sounds quite advanced in the example you're proffering. The extent of unresolved objections to the plan or to the policies or the modifications as proposed. And if they've already, if for example, an inspector's issued an interim findings report and he's said, well, I've noted these objections, but I think the answer is X, then you might say those objections have been resolved. And then obviously you'll also have to look at the consistency of the draft policy with the NPPF. Those are the three things that the framework tells us to look at when we're deciding how much weight to attribute to emerging policies.
And just to kind of have more of a discussion around that, I think on the second point, when one's dealing with outstanding objections, it's important to look at it both quantitatively and qualitatively, because as Isabella said, if the inspector has given you a pointer, an answer to how objections are going to be resolved, then the weight that you might give to the existence of those outstanding objections is different from if you have a kind of more unknown quantity or a greater number of unknown quantities in the form of the objections. And I often find at inquiry people simply say, oh, well, there are 12 objections outstanding to this policy, and that therefore is a reason why the weight to be given to an emerging policy is reduced. But I actually think it's really quite important to drill down into the substance of those objections and to work out whether they're good objections, whether they're objections capable of being addressed, or whether they're objections which could go to the heart of the plan as a whole and might be a real problem, in which case, if you've got a really good objection, you might very much limit the weight. So as Isabella says, you've got to look at those three factors in accordance with the framework, and you've got to form a judgment which is not just formulaic, which takes into account really the circumstances as they present themselves. But at least as a matter of principle, my answer remains yes. So in light of all that we've just said, we wanted to give a kind of overview of the principles, a takeaway message, if you like, on the first half of this presentation. And those 4 points were as follows. Firstly, that the NPPF doesn't displace the statutory primacy of the development plan, even where its most important policies are out of date. The second is that the age of a policy isn't itself relevant to whether or not it's out of date or up to date. What matters is whether it's deemed out of date, for example, because of a lack of housing land supply, and or whether it's consistent with the framework or some reason why it's out of date. The third is that even when the tilted balance applies, conflict with the development plan might be a sufficient reason to refuse planning permission. See, for example, that case in West Oxfordshire that I mentioned. And finally, an excessively narrow focus on the framework, those are words used by Lord Justice Sales as he then was in Gladman and Daventry, creates opportunities for cross-examination. So people like me or Isabella will take every opportunity to pick at that if all you're looking at is a particular section of the framework, and indeed can render a decision unlawful, which will result in a permission that ends up being quashed and a rerun of the whole thing. So those are the sort of 4 key learning points that we have in light of the first half of the presentation. And we're going to go on now to look at some worked up examples, some case studies, and Isabella's first.
Yes, and in the course of that, I'm hoping that I will respond to the question that's been posed by Michael Hutchinson, which is about whether there's any case law or appeal decisions on whether a policy about development limits is a housing policy, i.e. narrow definition, or a wider policy. And I'll come on to deal with that. Charles, remind me if I forget, please.
I'll try. I've been trying to keep the questions under control, but then I keep not doing the slides properly.
Okay, so I want to just look briefly at some appeals that I have been involved in Aylesbury Vale. And I've done a number of appeals for the council in Aylesbury, I think about 5. And those appeals together have involved somewhere in the region of 700 houses. And in each case, we have won the appeals, partly because developers haven't properly fronted up to conflict with the development plan. And in each case, the inspectors have found that conflict with the development plan, even though it's an old development plan, was enough to justify the refusal of permission. So as you'll see on the next slide, Aylesbury Vale District's local plan was adopted in 2004 and intended to run until 2011. Many of you may remember the difficulties that Aylesbury had in promoting a replacement plan, but I understand that its draft replacement is now almost there. But there, in the existing plan, a number of policies have been saved, but there were no saved policies at all relating to spatial strategy, settlement boundaries, or the supply of housing. None of those have been saved by the Secretary of State. But there was a particular policy, GP 35, which I've set out on the slide there. And there's some argument in some of the appeals about whether this was a policy that applied to outline developments at all, given that it came in the part of the plan relating to design. But inspectors and indeed the Secretary of State have consistently found that those parts of the policy that I've put in bold text there are applicable to outline applications. Now, GP 35, when I've acted for Aylesbury in resisting development, has always been my friend and really my only friend in the local plan, because there are so few other policies of relevance. So as I've set out on the next slide, the inspectors have consistently found that where a development would cause landscape harm or harm to the character of an area, even outline applications, it would be in conflict with GP 35. And GP 35 wasn't out of date, even though it was old, because it was consistent with the NPPF. Now, in the early days, there were some arguments about whether the NPPF had watered down the protection of the countryside, and there is certainly an argument that it has, although the court in the De Souza case, which I've relied on a number of times for local authorities, said that when the framework requires you to recognise the intrinsic character and beauty of the countryside, there has to be some response to that recognition, which is inherently a safeguarding one, because you recognise something and then you have to do something about that recognition, which is to try and protect the intrinsic character and beauty. So GP 35 was consistent with those aims of the NPPF, and conflict with that single policy in some of those cases. Sometimes in some of the cases there was also some heritage harm, but even conflict just with that policy, saved policy, meant that the development was contrary to the development plan read as a whole, and that was enough to justify the refusal of permission. So on the next slide you'll see and you'll recall that the version of the framework that came out in 2018, which is carried forward into the 2019 version, changes the wording of paragraph 11, formerly paragraph 14. And it put a slightly different spin on the arguments that we ran at Aylesbury Vale. So according to the 18 and 19 NPPF, the tilted balance is triggered where A, there are no relevant development plan policies, or B, where the policies which are most important for determining the application are out of date. And one such circumstance where policies may be deemed out of date is where there's no 5-year supply. Now, we argued that GP 35 was the most important policy for determining the application because it was one of the very few saved policies of any relevance to the application. And so in light of the wording of the revised NPPF, regardless of the age of that policy, we said that that was enough to preclude the application of the tilted balance. And this is where I just wanted to come in on Michael Hutchinson's question, because the question that Michael asked, I think summarising or paraphrasing, is whether there's been any further guidance from the courts on the narrow or the wider interpretation, and whether a policy about development limits is a policy for the supply of housing. But the wording in paragraph 11 of the NPPF is different now. So it doesn't talk about policies for the supply of housing being out of date. And so I'm not aware of any further case law on that, because the revisions to the NPPF have changed the focus. So now it talks not about policies for the supply of housing, but the policies which are most important for determining the application. And those most important policies, whether they're housing supply or other, will be deemed to be out of date if there's no 5-year supply. So the inspector in one of these appeals, well, a couple of them, but one is relevant, said that the first limb of paragraph 11 isn't triggered because there were some relevant development plan policies, i.e. GP 35. And the second limb wasn't triggered because GP 35 was consistent with the NPPF, so not out of date, and also because Aylesbury Vale had a 5-year supply, so it wasn't deemed to be out of date. And the developer, Paul Newman Homes, challenged the inspector's decision in the High Court. And the question for the court was whether a single policy in a time expired plan, in this case GP 35, was enough to prevent the application of the tilted balance. And the court found that a single policy was enough to preclude the tilted balance because, as I've said, it couldn't be said there were no relevant development plan policies, and nor could it be said that the most important policies were out of date, because in light of the limited number of relevant policies, the most important was GP 35. And so its existence alone prevented the application. And it's interesting because, as Charles explained before, generally the approach is to put all of the policies into a basket, all of the relevant policies into a basket and say, is the basket out of date? And what the developer was arguing was that Aylesbury shouldn't be in a better position simply because it hadn't bothered to have its housing supply or spatial strategies policies saved by the Secretary of State. It shouldn't be in a better position than those authorities which had saved those housing policies and which were now out of date. But because they hadn't been saved, the court was happy and accepted that GP 35 was was the most important policy. And in my view, the Aylesbury cases are just an example of the importance of never underestimating the role of a development plan. And whether you're resisting or promoting development, it's something that should always be at the forefront of your mind, whether you're arguing the scheme accords with it or trying to justify a departure from it.
Thanks, Isabella. Another question that we've got that I think fits in quite neatly here from Kate Gordon is, do these rulings suggest that paragraph 11 needs rewording? And I suppose that the first thing to think about is what paragraph 11 is actually designed to achieve. And a little pet hate of mine is people equating the tilted balance with sustainable development. And I actually think that the 2018 framework now says that, although I think that that is really a miswording, because sustainable development in ordinary world means meeting the needs of today without unduly compromising the needs of tomorrow. That's a paraphrase taken from the Rio Declaration. And certainly the 2012 framework understood and reflected that. And there were a multitude of ways in which you might benefit from the presumption in favour of sustainable development, one of which is according with an up-to-date development plan. So that would be a sustainable type of development in which there's a presumption, or in favour of which there's a presumption. And another way would be where the plan doesn't work, essentially because there's an out-of-date plan, you have to give more weight to reasons to departing from that, otherwise you won't meet the needs of today, and you haven't thought hard enough about which of the needs of tomorrow you need to compromise on. So that was the way in which it was designed to work. I think the 2018 framework in paragraph 11 places more emphasis on the tilted balance, or at least seeks to, although I don't know that it fundamentally means to change the outcomes. And as Isabella has explained with reference to Paul Newman Homes, sometimes it perhaps doesn't achieve what it intends to. So there might be scope for rewording, but there's probably a question anterior to that, which is what are you actually seeking to achieve in NPPF paragraph 11? I don't know, Isabella, do you have any thoughts?
I think probably paragraph 11 is intending, or for in the Aylesbury example, I think probably the government's intention would be for a local authority like Aylesbury, which just hadn't saved the policies which would otherwise have been out of date. Probably was that the tilted balance should apply in those circumstances. And if that's the intention, then perhaps a rewording would be just
in order.
Mm.
Thanks. Well, I'll move on to my case study now, which relates to the Camberwell Union proposal, which was a major central London mixed-use development. You can see the plan there, or the outline there. The idea was for a new cultural quarter. There were 13 of these blocks, many of them tall buildings, which were supposed to deliver 499 residential units on the upper stories, and then on the ground floor, 4,404 commercial, retail and leisure uses. And that was going to be a microbrewery and a series of what were called maker spaces, which are light industrial, because the site is an underused, indeed barely used industrial site. So it seemed right for development. And one of the reasons why I think this case is interesting is because the Secretary of State, notwithstanding what he's just said to Sadiq Khan in his letter that we'll look at later, issuing his direction, refused planning permission for this sort of mixed-use development on this site because of the way that the scheme had developed and been put forward, and ultimately because it wasn't essentially a good enough scheme. So what I wanted to look at was some of the things that might get skipped over when you read the inspector's decision or the inspector's report and the Secretary of State's decision letter, and in particular some of the contradictions that had emerged in the course of the developer's case. I admit freely I acted for the London Borough of Southwark in this case. You probably get a slightly biased view. But one of the things that was accepted very early on in my cross-examination was that all of the relevant development plan policies were up to date and were an effective strategy for achieving sustainable development. And I think once you accept that a development plan policy is up to date, you really have to accept that it's an effective strategy for achieving sustainable development, because if it's not effective in achieving sustainable development, then really you have to ask why you'd accept it's up to date. And having accepted that, there was also an acceptance that because of the loss of overall industrial floor space in this case, the development was in conflict with the council's strategic employment policy, which led inexorably to the conclusion that the development would conflict with an adopted and effective strategy for bringing land forward at a sufficient rate to address objectively assessed need over the planned period. And I pause there because it seems to me that at the very beginning of this, the acceptance that relevant development plan policies were up to date led inexorably to a rather awkward conclusion, and really more thought needed to be given to whether or not the developer in this case accepted that those policies were up to date, and more thought should have been given perhaps to what an up-to-date policy is, what that means. Because if we look at the way the developer put its case, what it said is, well, this development accords with the development plan read as a whole, so it placed an emphasis on judgment at that stage. And it said, and in any event, emerging policy is in favour of precisely this sort of development, of a mixed-use development, and if necessary, a reduction in employment floor space on this site. But only limited weight is going to be given to that emerging policy. And again, that just created this tension, because the developer, recognising the primacy of the development plan, wanted to accord with it, wanted to give that weight, wanted to use that as the way in which to promote its scheme. But then was trying to piggyback the emerging plan, which was saying something different from that, and accepting a different level, a lower level of weight to that. It created an inherent tension in its own case, which is really very difficult to resolve. And as I say, I think the reason for that was because there hadn't been this recognition that actually there was a conflict with the development plan. The development plan suggested that all of the industrial floor space on the site should remain, and the emerging policy suggested that there'd been a change in the need position in Southwark in relation to employment and industrial. There were different types of industrial use coming forward, and that smaller uses, and a greater number of them with residential stacked above them, was just the sort of thing which was needed. So there had been a change in the need position on the ground, which might have led the developer in putting its case to question whether it really wanted to accept that the policy which required all employment space to be protected was up to date, and to question its case as to whether it was really saying that this was a development which accorded with the development plan read as a whole. And so I think that places something of a spotlight on those early decisions when you're looking at the plan on a kind of strategic level. And then at the other end of the scale, on a more fine-grained level, in a design context, the developer was promoting this as a really very shiny scheme. And I'll kind of give a spoiler here. If you read the Secretary of State's decision letter, he finds that the quality of the development is so unacceptable that planning permission should be refused for it. And I think that really that problem had arisen again because not enough consideration had been given to the development plan. And when I had the pleasure of cross-examining the architect of the scheme, or the lead architect on the scheme, one of the things he said was that the design of the development hadn't been driven by the policy context. In fact, he was relatively ignorant, I won't say wholly ignorant, but relatively ignorant of a lot of the planning context. And it was clear that what had happened was the design team had gone away and developed a design for this location, and then they'd sought to retrofit the development plan onto it and to show how it accorded with the plan, having designed the scheme. And that's not really the way that the planning system expects things to happen. It expects there to be a policy for the area, and then for someone to look at that policy, respond to it, and develop a scheme which accords from it or which departs from it as necessary and justifies those departures. And so by reverse engineering that process, by pulling on that thread I mentioned at the beginning, it kind of showed up that the development simply wasn't plan-led and it wasn't responding to the design policies in the plan in the way that it should have. And a particular example of that was an attempt by the developer to apply a strained interpretation to one of the policies in the plan, which dealt with density and the quality of development. And this was a scheme which exceeded by 40% the top end of the relevant density range. And there was certainly flexibility in Southwark's then adopted development plan, which allows for exceedances of the density range, but it requires, on a proper reading, an exemplary standard of design in those cases. And the developer was seeking to have its cake and eat it and to say that although, yes, of course, our development is exemplary, it doesn't matter if it's not, because even if you exceed the top end of the density range by 40%, you don't need to be exemplary. And that was a really very difficult construction of the development plan to be maintaining, but it also suggested a lack of confidence in the quality of the scheme. I mean, if you go before an inspector and you say, well, our development doesn't need to be exemplary in standard, then that starts raising question marks about the quality of the development you are putting forward. And I think it's fair to say that it's quite rare for a scheme of this size to be refused by the Secretary of State essentially on the basis of detailed design. And the fact that that did happen, and essentially because of a failure to focus on the development plan, I think really is something which should give people food for thought. So I've tried to come up with 3 suggestions for how that sort of case could be dealt with better in future. And the first thing I would say is that development should, from the design stage, be informed by development plan policies. And I put on the right one of the things that was put in evidence by the architect, where they've clearly done a huge amount of work on the nature of the south side of London and how this development was going to fit in to the ethos of the part of London in which they were developing it. But it's worth noting that there's a development plan which covers almost exactly the same area as that picture. And I think it would have been helpful if, in addition to that, there had been the same level of detailed consideration of the plan and what it expected in those parts of London. The second thing is to think more carefully about whether policies really are up to date in your client's view and in your professional view as well, because whether something's up to date is ultimately going to be a judgment call, and particularly where circumstances have moved on, where a policy is need focused, as an employment land policy is, then where there have been massive changes in need over a period of time, then the timelessness of the policy isn't going to apply. It's not like the countryside, which is beautiful. It's inherently something which responds to the demography. And so perhaps more consideration of the demography and a more careful thought being given to up-to-dateness in the context of policies which aren't housing policies would have benefited the promoter in this case. And the third thing is really presentational, but it's the one, at least for me, that makes the most difference in the most cases. It's just where there is a conflict with the development plan, recognise that up front, justify it and explain why you're departing from the plan, because it's so much harder for Isabella or for me to cross-examine a witness who says, yeah, we depart from the development plan. I recognise there's a conflict with that policy, but I just attribute relatively limited weight to it because that's not really the focus, as Ulkama said. Than for us to be able to fight with someone who's saying, oh no, it definitely accords with this policy in circumstances where on the plain meaning of the words it doesn't. And then we can, to some degree, embarrass the witness, and it just creates a bit of a momentum for the case that we're putting. So if I could give 3 top tips as a result of that case, those would be them. I think Isabella's now going to talk a bit more about the future.
I am. I was just going to answer Julia Day's question. I think, Charles, I might rope you into this as well, because her question is about other material considerations and what status ministerial statements and the PPG have, and whether there's a hierarchy with the NPPF at the top. Generally speaking, the weight that's given to any consideration is a matter for the decision maker. So there's no law on it, really. In practical terms, I think probably there is, people do approach it as something of a hierarchy with the NPPF at the top. And the reason I was going to rope Charles in is because I know he had a case in which he was disparaging the PPG to a certain extent, and the High Court agreed with him.
Yeah, that's absolutely right. There's another case on written ministerial statements, which is to a similar effect to the case I'm going to mention. I can't remember the name of that, but I'm sure we can send it out with the slides. The case I was involved in is a case called Solo Retail. I was acting for a retail developer. Their permission was challenged by a rival. There is out of town retail, good old fashioned kind of store wars style case. And what was said was that the retail impact assessment that my client had provided and the local authority had relied upon had not met all of the detailed criteria in the PPG, and therefore there'd either been some sort of misinterpretation of the PPG or that there'd been a failure to recognise a conflict with it by the local authority and to give reasons for that. And when I looked at it, I thought, frankly, that the PPG on retail impact assessment was a little internally inconsistent. And the judge, Mrs. Justice Leven, so she's Natalie Leven QC when she was in practice, I could tell in the course of the hearing was interested in the status of the PPG and frankly was willing to say something about it. And so I made submissions saying that the PPG, unlike the NPPF, isn't publicly consulted upon. Its publication online is frequently changed. It's subject to regular updates, and it's not given the same level of legal care and scrutiny as the framework. It's guidance rather than policy. And although there's no kind of legal distinction between the two, there's an intention on the part of the person who publishes them that they should have different status. The NPPF is a single codified statement of government policy. The PPG seeks to flesh that out. And Natalie Leven, in this case, Solo Retail against Torridge District Council, says quite clearly that the PPG is of a lower status, that one needs to be careful when one looks at it and interpret it broadly. And so if anyone is ever looking for a case to use to hammer the PPG, Solo Retail is your friend.
Okay, and finally, this is our last slide, just a quick look at the future of the development plan. So in March of this year, the Department for Housing, Communities and Local Government published Planning for the Future, which is a precursor to the planning white paper, which is due to come out imminently. And one of the stated aims in Planning for the Future is to encourage local planning authorities to take a more proactive approach to enable house building across the country. And all local planning authorities are to be required to have an up-to-date local plan by 2023 or to face government intervention. And the Local Government Association has responded rather curtly, saying that it's vital that the government doesn't take away any more of the powers of councils and communities over planning development in their local area. And it suggests that the Local Government Association at least perceives that the local development plan may be under threat again from central intervention. And so I think it just we'll have to wait and see how that plays out and what comes out in the white paper. But it seems that this tension, because ultimately the NPPF is a government document, and there has been this tension between the centralised approach to planning and the local development plan documents, and it seems that that tension may persist or indeed become inflamed again.
Yeah, and I think that ties into a question that Alan Lodwick's asked, where he says, any comments on South Oxfordshire where the Secretary of State is insisting the LPA proceed with the plan that it doesn't want, partly because its existing plan is out of date? And I think what's happening in South Oxfordshire and what's happening in London as well, that I'm going to go on to talk about, is emblematic of the government's approach and the tension that Isabella's just referred to. Because what the government wants is local development plans which achieve the national policy objectives it has in its NPPF, and indeed at the heart of the government's economic and housing policy in this area. And I think that the difficulty is that the statute gives a lot of the duty, a lot of the power to local authorities. And so the government is trying to impose top down on local authorities its vision for the planning system, whilst at the same time maintaining its conservative, with a small c, vision of how the planning system should work, which is really a local based system, which centres around a plan put together by local politicians and local officers who assist them. And I think that tension between the centralised government desire to get the housing market in particular moving, to provide new homes and to force local authorities to do things, and between the local authorities who inherently respond to what their constituents are saying, which very often is, please could I have no more houses on the beautiful fields behind my house, is really difficult to reconcile with the present system in place. And to some degree, I know a lot of my older colleagues in chambers would say that stems from the absence of regional spatial strategies, which filled the gap between two and gave the opportunity for local authorities to say, well, it's not really my fault, Gov, and for the government to give some strategic direction to the local development plan process. And I think it's really the absence of the regional spatial strategy that is informing this kind of tension between the local authority and central government in places like South Oxfordshire. Isabella, do you want to add anything to that before I move on? Well, perhaps then I turn to the London plan, which is essentially the last remaining regional spatial strategy. And what I really wanted to touch on was the letter from Robert Jenrick to Sadiq Khan, sent on the 13th of March 2020. And it will be no secret that the relationship between the Ministry of Housing, Communities and Local Government and the GLA is a pretty fraught one. I brought a judicial review for RBKC recently, which was extremely aggressively defended by the GLA, right up until the moment where they were forced to disclose all of their internal documents, at which point they conceded that they've been acting for an improper purpose in granting planning permission for one of the biggest developments in London, a very tall building in Kensington, essentially because they were cocking a political snook at the Secretary of State. So, I mean, there really is a lot of background to this, but the letter on the 13th of March from Robert Jenrick is in surprisingly aggressive terms to Sadiq Khan in relation to the London plan. And he says that the housing delivery in London under his mayoralty, Sadiq's mayoralty, has been deeply disappointing. And the thing I really want to focus on is this passage, and I'll read it out. He says, "Your plan adds layers of complexity that will make development more difficult and unnecessary, with policies on things as small as bed linen. Prescription to this degree makes the planning process more cumbersome and more difficult to navigate, in turn meaning less development comes forward. One may have sympathy for some individual policies in your plan, but in the aggregate, the approach is inconsistent with the pro-development stance we should be taking, and ultimately only serves to make Londoners worse off." And Sadiq's responded to that last month, at the end of last month, but I think there are 2 points I really want to make as a result of it. The first is that the London Plan is a regional spatial strategy, and one of the big criticisms that you see there coming from Sadiq Khan is that it's trying to do the job of the local planning authorities. It's trying to tell people exactly what to do in as much detail as talking about bed linen. And that really isn't the role, I think Robert Jenrick is saying, of a regional spatial strategy. That's something which should be left over to the London boroughs to make policies on if they see fit. And I think the Secretary of State would be pretty unhappy if they were making policies on matters of detail, because as we said at the very beginning, the government's idea ultimately is to try and cut red tape in the context of the planning system, not to add it to the nth degree. So that's my first point, is that there's an attack on that. The second is, I think, the reference to the pro-development stance and the need essentially to push for more development. And that almost comes from the other end of the scale. That is the government still giving its top-down push. It wants the regional spatial strategy in London to give a drive to local authorities to deliver housing. And the Secretary of State has here used the nuclear option. He's made directions in relation to particular policies in the plan. Interestingly, in light of the Camberwell Union decision letter, those policies relate to mixed-use developments. In particular, one of the things he's saying is there needs to be better optimization of density, more mixed uses, stacking of developments to make sure that London provides the housing it should. But this is really a watch this space, because I think that the fight, for want of a better word, that is unfolding between the Mayor of London and the Secretary of State is to some degree going to be a microcosm in which we see the issues in relation to the development plan and government policy fought out in the course of the next year or so. And Isabella, unless you have anything to add on that, we might turn to deal with some of the questions that we left behind.
I think some more may have arisen. I think, Charles, we have 3 minutes remaining of our allotted time, and the one thing we promised each other we wouldn't do would be overrun, because we're grateful that people have stuck with us this long. So I wonder if we might leave it. We've put our email addresses here on this final slide, and we'd be very happy if people have any specific questions or queries arising from any part of our discussion today to respond to those. And I must also mention that FTB is running a series of online webinars, and you are all cordially invited to them. So please do go onto the FTB website where everything's set out, and do register if you'd like to join in any of those others. So Charles, unless there's something that you want to answer in the next minute.
No, but do email me, because we're all sitting at home. So by all means, send that on.
We will leave this slide up here in case you want to make a note of our email addresses. But we will now remove ourselves. Thank you for joining us, and we really hope that you found our talk today useful.
Yeah, thank you very much indeed.